I didn't mean to interrupt your question.
Glenn, can I say something?
Sure. Are you recording?
Yeah.
It's open.
I think everybody knows I'm Mayor Stan Mills. Thank you for being here. And I want to remind everybody, of course, you know why you're here, because you are on a city commission, board, committee, or task force. I want to thank you for your service to the city. And also, because you are a member of a committee, commission, board, or task force, that means you actually are part of our city government. And a very important part of city government is obeying the Freedom of Information Act and our ethics laws to keep us all out of trouble. And so that's what this meeting's all about today. So thank you for being here. And this is going to be recorded so that you can go back and watch it over and over and over again. If you like. Thank you. Thank you.
You're promising way more than I may deliver. So I just want to mention that this is noted as a special meeting of the commissioners on the website. Due to it's sort of a technical thing, we have to open it as something to be able to post an agenda through the online system. So that's why it's noted that way. But this is actually just a straight training session. So we're going to talk today a little bit about Freedom of Information Act and ethics. When I do these sessions, I really like them to be a little bit more interactive. So if you have questions, feel free to stop me along the way. Sometimes there'll be a slide later on that's going to address your question, but I'm happy to take it at whatever pace you want to and make it a little bit interactive. So we're going to be talking about Delaware's open meetings law that's contained within the Freedom of Information Act, and you see the statute noted on the screen there. We'll be talking about two components of the Freedom of Information Act. That's open meetings and open records. Meetings being the meetings that typically happen in this room. Records being all kinds of documents, both written and digital. And we'll see that those two categories within FOIA create a lot of tricky questions that seemingly the material looks simple when you first start to think about it. Then there's a lot of little nuances that we'll get into. Then we're going to talk a little bit about ethics. The city of Rehoboth Beach is subject to the state code of conduct, and you see the statute where it is there. All of you, by virtue of being within city government, are subject to the state code of conduct, and we'll get into that. So first, let's start with Freedom of Information Act. Here's the policy that's in the statute itself. The important part is that citizens shall have the opportunity to observe the performance of public officials and to monitor the decisions that are made by such officials. So the idea behind the Freedom of Information Act, some people call them sunshine laws, is to shine the sun on what government is doing. People are supposed to be able to see and observe what government's doing, not necessarily participate in the decisions being made by elected or appointed officials, but at least observe it at the very minimum. So what is a public body? So these public bodies are what are subject to the Freedom of Information Act. A public body, this kind of lays out what it is. Clearly the Board of Commissioners, the elected officials, they're a public body under the statute, but the statute goes a lot further. So a public body includes, under the statute, any regulatory, administrative, advisory, executive, appointive, or legislative body of any political subdivision of the state. That means any board, bureau, commission, department, agency, committee, ad hoc committee, special committee, temporary committee, advisory board and committee, subcommittee, legislative committee, association, group, panel, council, or any other entity or body is subject to FOIA. The reason I always quote that is because it's very, very broad. It's very, very broad. I mean, sometimes people say, well, let's just do an ad hoc committee and it's not going to be subject. So, the chairperson will say, hey, how about Alex and Laura, you two form a committee, go work, or an ad hoc committee. You guys just go work on this and come back and report to us. That simple act created a public body under the Freedom of Information Act, meaning that when they go to do the work that they've been asked to do by the chairperson of their committee, they now are subject to the Freedom of Information Act. They have to notice their meetings with agendas. They have to be open so that the public can come view them. So it's very, very broad, and I always get nervous when that kind of activity happens at the dais where somebody says, well, I'll go look at that, and maybe I'll have Bob help me out. And the chairperson says, okay, great. And in my mind, I'm like, put on the brakes, because that was the creation of a public body that's subject to the Freedom of Information Act. Yeah. Yep.
One person says, I'll check that out and get back to the rest of them.
Good question.
By him or herself.
Good question. So there's It's not within the statute, but there's something called a body of one, which is when it's just one person appointed, and that one person is not subject to the Freedom of Information Act. They can go do their work and come back and report to the committee. In fact, that one person can be appointed, and that person in their work or whatever they've been asked to do, they might on their own say, well, I know that Sarah on our committee is really good in this area, so I'm going to ask her a few questions. But it's still just the body of one working by themselves. That person is not subject to the Freedom of Information Act in that scenario. A lot of times that comes up with city managers actually. A lot of times a city manager will be calling meetings and having things, in their office, and people will say, well, why weren't those meetings open to the public? And it's because the city manager is a body of one, and he or she may operate that way without having to have all those meetings open to the public. So the statute actually lays out that FOIA applies to any group that, one, is supported in whole or in part by public funds, or expands or disperses any public funds, including grants, gifts, or other similar dispersals and distributions. So you get through 1 and 2 and you think, oh, it's all about money. If you're spending city money, then you're subject to FOIA. 3 says, is impliedly or specifically charged by any other public official, body, or agency to advise or make reports, investigations, or recommendations. And that's typically what we do. We'll set up a subcommittee to go research something on trees and come back and report back to, and that's, so number 3 makes them subject to FOIA. So if it's related to the town, county, city, or state agency, even an ad hoc committee like we just talked about a moment ago, the open meeting requirements apply. But remember, it only applies if there's a quorum of members present. That's when there's a meeting of a public body. Because recall, this is all about meetings of public bodies that have to be open. So if you are a 5-member committee, a quorum is a majority, which is 3. So if 3 people get together, oops, I'm sorry. Is it not recording? Sorry for that interruption. Since this is being recorded for people to watch in the future, help me remember to repeat the question so that it makes it onto the recording, or we can use the mics. And what's your preference? Either way. I'll just repeat them because I don't want you to have to keep getting up and down. So the question that was asked earlier that answers was, what if it's only a single person that's asked by a chairperson to go and look into something and report back to the committee? And the answer was that's what's called a body of one, and it is not subject to the Freedom of Information Act. You don't have to have open meetings and agendas. So we're talking about quorums. So I was mentioning that if you had a committee of 5, quorum is a majority, so you'd have 3 members, makes a quorum. So if 2 members wanted to get together to talk about something, even if it's public business related, they can do that without being subject to the Freedom of Information Act. They can't make any decisions that bind the body. They couldn't take a vote, the 2 of them, that would bind the body of 5. But 2 people can get together and it's not subject to FOIA. But once you get to that 3rd person in a body of 5, then all of the Freedom of Information Act requirements kick in.
Glenn,
Yes.
so back to the, so you don't have a body of one, but if you have 2 people and those 2 people constitute an ad hoc committee, though, that would be subject.
It would be. That's correct. So the question.
Call it an ad hoc.
That's right.
Okay.
So the question is, I just mentioned that 2 people on a 5-member body can get together and talk about public business and is not subject to FOIA. That's true, but the question was, what if those 2 people were appointed by the chairperson? Then then they are a committee that's subject to FOIA. That's right. So a public meeting for purposes of FOIA means the formal or informal gathering of a quorum for the purpose of discussing or taking action on public business. So a quorum, again, in the city, a quorum is a majority of the membership of the body. Now, it doesn't always have to be that. By statute, you can change it and say that 2 members of a 5-member body constitute a quorum, or 4 members of a 5-member body constitute a quorum. But in the city, I can't, off the top of my head, I don't know of any board, commission, committee that's anything other than a majority is what constitutes a quorum. And you have to be getting together as a quorum for the purpose of discussing or taking action on public business. That's what constitutes a public meeting. One, you have a quorum present, and two, you're discussing and taking action on public business. So you could have a 5-member committee, and all 5 members can get together to watch the World Cup and talk about the soccer game and do all those sorts of things. No problem at all. Those 5 people in a room doesn't matter. But when one of those 5 people says, hey, I see on our agenda next week, we've got this item coming up. How do you feel about it? And the members start talking about the public business, even if they're there to watch the soccer game. That constitutes a public meeting of the body, and it should have been noticed, and it should have been an opportunity for the public to come and see it. Questions on that? Yes.
Yeah, I do. I remember when I was on the Board of Adjustment that it was a party at one of the members' houses, and he was very careful to make sure that there weren't a quorum of us in the house at one time. But that was unnecessary, and that was what you're saying, as long as we never discussed any official business. Is that what I'm hearing?
That's right. So the question was, well, it was a recollection of a time when an individual serving on the Board of Adjustment was going to attend a cocktail party or a gathering of some sort, and the party planner was careful to ensure that there wasn't a quorum of members of the Board of Adjustment present in the house at any particular time. And that, you're right, that was unnecessary. I see that happen a lot. I've seen through the years, groups avoid being at a Chamber of Commerce meeting together, but you actually can do that. You can be all of you in the same room, so long as you're not conducting public business. Yeah. Another question.
What's the consequence if you do have a discussion and it has not been noticed, there's no agenda, there's no record?
So the question is, what's the consequence if you do have a public meeting that has not been noticed with and does not have an agenda? And the answer is, there's no consequences unless somebody wants to bring an action before the Attorney General's office. Under the statute, somebody can file what's called a FOIA complaint, and it basically is a petition that says, I know this meeting happened, it wasn't noticed, I'm a member of the public, I wasn't able to attend and observe what happened. And the AG's office then will investigate, and if that meeting actually did occur, so it was an illegal meeting, the AG's office will typically, in that instance, nullify any decisions that were made and require that the public body notice a new meeting, conduct the meeting, and do it in public. So that's some of the teeth in it, in the statute. The other side of it is you can also go before the Superior Court or Court of Chancery, I think Court of Chancery, on FOIA violations, and the Court of Chancery has a little more teeth that they can use to remedy the situation. But typically, it's at the AG's office. All right, so public meetings. The general rule is subject to a few exceptions. Every meeting of all public bodies shall be open to the public. We're just talking about that. If there's doubt, the meeting should be public and follow the statute. So when I was in the military, you always, when you're first in, you're trying to get the rank structure down. You're not really sure whether to salute or not salute, depending on who's outranks who. And we always said, when in doubt, whip it out. It's the same thing here. When in doubt, just have an agenda, do a public meeting. If you're not sure whether it needs to be subject to it, go ahead and just notice it as a public meeting. Meetings must be held within the jurisdiction of the city. And this is interesting. So during COVID, the statute was amended to allow for a virtual option, to have meetings virtually. In the city, once we turned the corner on COVID and we're allowed to have public meetings again. The policy here has been to have all meetings be public and not virtual. The last legislature tried to extend the virtual option within the statute. They messed it up. And so they changed all the language to say that it was going to be extended. Then in the last phrase where it says when this ordinance becomes effective or when the statute becomes effective, they said that I'm trying to remember how exactly it happened. Basically, they did the opposite of what they were trying to do. They tried to say it becomes effective as soon as the legislature passes it and the governor signs it. They did the opposite, and they basically repealed the legislation they just passed when the governor signed it. So now it's an open question as to whether we can have virtual meetings or not. The FOIA Coordinator's Manual, which Ann gets every year or 2 years, The last one came out in October of 2021, which was after the June 30, 2021 expiration or alleged expiration of FOIA. The coordinator's manual still allows for a virtual option. So I think the coordinator's manual was in production. They were realizing that the legislature was going to extend the virtual option. So it's in the manual that you can do a virtual option. But if you read the statute right now, it's been repealed. So, but there are a lot of jurisdictions around the state that are still doing virtual meetings, notwithstanding the fact that the statute doesn't allow for it anymore. So I think that's will be taken up in the next General Assembly. Special considerations. FOIA does not prohibit members of a public body from participating in other groups or attending other functions so long as those gatherings do not discuss as a quorum the public business of the public body which they are members. So that's what we just talked about. We can watch a soccer game together. We can go to a cocktail party together. We just cannot convert that group activity to public business. Here's a little cautionary item that is probably 30% of the FOIA complaints that are filed. It happens because of what are called serial meetings. Serial meetings are, and email is a perfect example of this. A serial meeting is a meeting that occurs, but it doesn't occur in one setting at one time. So I send an email to Alex, we're on the committee together, and I say, hey, we have this thing coming up on our agenda. So let's say it's a 5-member body. We have this thing coming up on our agenda. I'm thinking this way. I kind of like this idea. I don't like that idea. What do you think? He tells me what he thinks by email. So now we've got an email thread between the two of us. Again, no problem. It's just not a quorum, right? We're just discussing public business, but we haven't reached a quorum yet. So that's fine. But then when Alex decides to forward the email to Laura, and my email's on it, his email is on it, and she responds and says, I think that's a great idea. I think I'll go that way during our meeting as well. I like that idea. Now we've got a serial meeting. It didn't happen all in one place, all at one time, but 3 out of a 5-member body are commenting on public business and consensus building. That's actually a public meeting that is supposed to occur in the public view. So those are serial meetings, and it can be by email, telephone. It can be 2 people talking on the street, and then one sends an email to the 3rd member. Any of those mechanisms or methods by which you get a quorum participating and talking about public business still constitutes a public meeting. Sir.
So if I were on a committee and I sent an email and CC'd a quorum of that committee, that would be a meeting?
Okay, so that's a great question. So the question is, if I'm on a committee and I send an email and I CC the entire membership of the committee, does that constitute an illegal meeting? And the answer is it could, but not always. So if it's a passive communication, so if you have a report and it's relevant to an item that your group's going to be discussing at their meeting next week, and you say in an email, I'm forwarding this to all of you, so you have this background information for our meeting on Thursday. That's no problem. That's a passive communication. You're pushing information one way. There's no exchange, no consensus building. You're just providing a document. When it becomes a problem is when the next person emails back, hey, look at page 34. I think this is directly on point to what we're doing. That's why I'm going to be voting this way. Who's with me? That's when it starts to be, that's when it becomes a conducting public business and consensus building. So passive communication. It is.
Say in the email, do not reply.
Right. So,
Could create a meeting inadvertently.
right. So what we're commenting on for those who are watching this online is that it's sort of a slippery slope when you send out that email because people are inclined to write back. So typically what we do is we put on the email, do not reply all, because replying all, then you start that consensus building and that serial meeting. So I agree that those emails should be sent out not frequently, only in certain instances, and you always put the disclaimer on it, do not reply all, because if you reply all and you're consensus building, then it's a public meeting. Yeah.
What if Ann sends out the document to everybody?
So the question is, what if the city secretary sends out the documents or the information to the entire committee? And same thing, that's not a violation. It's not FOIA. She can do one passive communication like that sends it. Now, same thing though. If Ann sends the information out to an entire committee, No problem there. But it's the same idea. If one person writes back to the group and says, look at page 34, I think that's great. We should all be thinking along those lines. And that discussion starts by email, then you again have a public meeting. Even though the city secretary initiated it, if you have a quorum of people talking by email, it's still a public meeting. Okay. This is the big red slash through it because this is a slide that I used to actually present, but I can't present anymore. So this says that, and members of the public used to be offended by this slide because it says, although FOIA entitled, and this is from a Delaware Court of Chancery case, it says, although FOIA entitles citizens to notice of public meetings and to attend meetings of public bodies, FOIA does not mandate that public bodies allow for public comments at any or all meetings. There is nothing in the text of the Declaration of Policy or the open meeting provision requiring public comment or guaranteeing the public the right to participate by questioning or commenting during meetings. What is provided by FOIA generally and by the open meetings provision in particular is public access to attend and listen to meetings. So it used to be that a public body could have a public meeting, you as a member of the public had every right to attend, observe, watch what was being discussed, watch how they voted, watch what comments they made. But as soon as you raised your hand to make a comment as a member of the public body could say, you're only here to observe. There's no requirement that we allow any member of the public to speak. That's changed. In October of 2022, House Bill 293 was approved, and now the statute says a meeting that is open to the public must include time for public comment. The time for public comment must provide a meaningful opportunity for the public to engage with the public body. A public body may impose reasonable time, place, and manner restrictions on the length of the public comment period and the amount of time allotted for each public comment. There's been some discussion about what this phrase, opportunity for the public to engage with the public body means. Some have argued that that means there's an opportunity for the public to raise questions and the public body must respond to them. I think the better view is that the opportunity for the public to engage is just the opportunity to comment in a meaningful way. I don't think the public body is required to respond because, again, you'll see in a little bit that you have to have an agenda for each of your meetings and you can't deviate from that agenda. So if the public's allowed to ask questions and you're required to respond to them, arguably you'd be deviating from the agenda and talking about topics that aren't on it. So I think even though this language is a little bit arguable, it still only means that the public has a right to comment. The public body is not required to respond. Now that's for public meetings. Public hearings are different than a public meeting. FOIA allows for general public comment in a public meeting, which is what we just discussed. Procedural due process requires notice and a right to be heard if it's a public hearing. So public hearings are usually things that deal with a person's constitutional rights. That's why in zoning code amendments where we're dealing with private property, if the commissioners want to adopt an ordinance that's going to change somebody's rights with regard to their private property, the city commissioners are required to conduct a public hearing in addition to their public meeting. At a public hearing, you're required to allow the public to speak, and the commissioners are required to take their comments, the public's comments, into consideration when they're making the decision. So that's different than a typical public meeting under FOIA. Public hearings are typically found in different statutes, and they're required by different statutes. FOIA doesn't require a public hearing for anything, but in other instances, and you'll find in the state code and in our city code, an actual public hearing is required. So here's the agenda we just mentioned. Public bodies have to give notice of their meetings. They have to do it at least 7 days in advance thereof. So the agenda actually has to be posted 7 days before the meeting occurs. We post them on the city's website, but there's also a board. When you walk in City Hall downstairs, there's a board right to the left of the main doors that go back to the admin area. That board's not there just to be there. Every jurisdiction's required to have a board like that where they post all of their agendas of all of their public meetings. And this 7-day thing is funny because, government gets, I think, sometimes a bad rap for not moving quickly. But think about if you had to live your life in 7-day increments. You had to know always 7 days in advance what you're going to do. And you have to publish that agenda. So, there's a number of times where will be 3 days before a meeting. There will be something that we as a government would like to get accomplished, and there's a meeting happening, but we're inside of the 7-day window. We can't put it on the agenda, and we have to wait for another agenda, 7-day period, to have that discussion and get that action done.
So when, from time to time, Ann needs to give us amended agendas.
Right.
So that's still within the purview of the published agenda at the beginning.
So the question,
It's not a new case, for instance, or a new.
right, so the question is, can you amend the agenda within that 7 days window? And because sometimes we do. And what the cases have said is that if you need to amend the agenda within the 7-day window, you can do that so long as there is a reason that the public body could not have waited another 7-day waiting period. So I've seen instances where the public body has a meeting noticed, and for example, grant monies become available, but the deadline for making application for those grant monies is less than 7 days out. And if the public body wants to take advantage and have an opportunity to obtain those grant monies, they have to vote on it as a city council or as a group of commissioners. And they will amend the agenda in that instance and say, our deadline is this date, we just found out about it, so we needed to amend the agenda to be able to take action. But it's really in limited instances. Ann, did you want to comment on amending the agenda at all? I should probably put you on a mic, right?
Okay. Typically, when the agendas are amended, it means that I am embedding documents into the agenda, and that is a requirement by the AG's office that I must amend those agendas. That's pretty much why the agendas of late are amended constantly. I haven't seen any other ones other than deleting something off the agenda, then it has to be amended.
Right. So sometimes the documents that support an agenda topic, so the agenda topic got noticed within 7 days earlier, but then, right, correspondence will come in related to the agenda item, or the commissioner who sponsored the item has a support document that they want included and embedded in the agenda. So that sometimes is a reason for amending the agenda as we embed those documents into it.
And when I embed, I have up to 6 hours prior to a meeting to be able to embed. So the reason when people send me correspondence or documents that need to be embedded over the weekend, and the meeting is on a Monday, I cannot embed until after the meeting has been taken place.
Right. So if someone comes in within that 6-hour window, it's not going to get embedded, and we always ask people to get things in much sooner than 6 hours before the meeting anyway. The second bullet here it talks about instances of a need to have an emergency meeting for the immediate preservation of the public peace, health, or safety. So it has to be something very significant, like a hurricane, tornado, riots, those sorts of things. You can't sort of make up an emergency to make up an agenda, so it has to be a real emergency. The meeting agendas must include a general statement of the major issues expected to be discussed at a public meeting. That's all the statute requires. I think we do a pretty good job in the city of Rehoboth Beach at giving a little bit more on our agendas so people have a better idea, a better understanding of what the topic actually is. There is a case called Iani that said, while the statute requires only a general statement of the subject matter to be addressed by the public body, when an agency knows that an important specific aspect of a general subject is to be dealt with, it satisfies neither the spirit nor the letter of the Freedom of Information Act to state the subject matter in such broad generalities as to fail to draw the public's attention to the fact that specific important subject will be treated. This case, I think, involved, if I recall right, they were going to appoint a superintendent of a school district, and the agenda just said something along the lines of personnel matter or something like that, and they're appointing the new superintendent of the school district, so that wasn't enough. The agenda should have said more. Here's the notice requirement. Public notice required by this subsection shall include but not be limited to conspicuous posting of said notice at the principal office of the public body holding the meeting, or if no such office exists, at the place where the meetings of the public body are regularly held. So that's the panel I was talking about downstairs, where the board where we actually post all the agendas. You're also required to keep meeting minutes at any meeting of the public body. Anne is the one who takes all these minutes, and you'll see sometimes if you ever make it into the administrative part of the building, her office door sometimes is closed, and there's a placard there that says meeting minutes in progress, like, don't bother me, I have a million of these meeting minutes I have to get out. So she spends a lot of time on meeting minutes. The interesting thing is that the only requirement is that the minutes include a record of those members present and a record by individual members of each vote taken and action agreed upon. So the minutes can be very, very slim. Some jurisdictions do it that way. Anne's minutes, as you all probably know by now, are very, very detailed. And it's been very, very helpful in instances where we're trying to remember what happened 6 years ago and why did this particular public body make that decision. You can go back and read the minutes and get a pretty good flavor of what was going on at the time using Anne's minutes. Other jurisdictions aren't nearly as comprehensive. That's a little plug for you, Anne. There's no clearly implied statutory requirement to summarize the subjects discussed with any degree of specificity in the minutes that FOIA requires to be prepared and maintained. That's from the Common Cause case. I was just mentioning that, but Anne goes further than what this case requires. All right, so that's the basics of the first part of the Freedom of Information Act as far as meetings go. This is the last part of the meetings part, which is executive sessions. This is the time when the public body is allowed to meet outside of the public view. Limited instances, the public body can say, we're going to have an executive session now, we're going to do it privately, and the public will not be allowed to observe. So this case says any exceptions to the open meeting requirements are to be construed very narrowly. Open meeting laws are liberally construed, and closed session exceptions within these statutes are strictly interpreted to limit non-public meetings. So an executive session should be the exception to the rule. You shouldn't be meeting privately, more than you're meeting publicly for sure. But so the city commissioners, I would say we've had executive sessions this year. There were some when the new city manager was being decided upon, but it's been a handful of them this year. I mean, it's not been dozens or even probably not even a dozen, probably much less than that. So here are some of the exceptions that allow you to have an executive session. Litigation and collective bargaining strategy sessions. So if you're in litigation with an opponent, you don't want to talk about the litigation in an open session, especially if you're talking about strategy, because your opponent is able to sit in the public meeting and listen to your strategy. So you can do litigation in an executive session. Collective bargaining is kind of the same thing. You're going through a process of negotiating a labor union contract. You don't want the labor union to know what your negotiating strategy is, so you can be in executive session for that. Same thing with discussions on the sale, purchase, or lease of real estate. You don't want potential buyers to know that you're going to sell a property for a certain price, so you can talk about those things in executive session. Discussions which could disclose the identity of a charitable donor who wishes to remain anonymous. That one's self-explanatory. Some personnel matters, including employee discipline and the qualifications of most job applicants and employees. So this was, for example, when we were looking at the new city manager, the qualifications of the job applicant. So, when we were talking about different applicants and who would be the right applicant for the city, those are things you can talk about in executive session. The litigation exception, I like to spend a little bit of time on that because that's typically where a public body will go. If they're trying to find a way to get into an executive session, well, this could cause litigation. This could cause litigation. We got to go to an executive session. Anything can cause litigation. So it has to be something more than just this could cause litigation. So when determining whether litigation is likely or reasonably foreseeable, the public body should look for objective signs that litigation is coming. For example, a written demand letter in which a claim is asserted or action is demanded may give rise to a proper inference that litigation will soon follow. So for example, if the Planning Commission has a subdivision application before it and they've got to decide whether they're going to vote to approve it or not approve it, and the planning commission has sent a letter from an attorney saying, you know, good rotten scoundrels, if you approve this, I will sue you, that's enough. At that point now, we can go into an executive session and talk about the potential litigation, consequences of approving or disapproving the application. But it has to be something that rises to the level of a real threat, and that litigation is reasonably foreseeable. Other indicators of potential litigation might include previous or existing litigation between the parties. So if we have somebody litigious in the community who has sued the city 2 or 3 times, the 4th time, you don't have to have the indices of potential litigation don't have to be up here. It can kind of be he might just say, I think I'll sue you. And that's enough probably when you've been sued 3 or 4 times. The public body must be able to point to a realistic and tangible threat of litigation characterized with reference to objective factors before it may avail itself of the potential litigation exception to FOIA. So I spend that time on this one just to keep in mind when you're sitting on whatever public body you are on, if you're actually going into an executive session for litigation, just ask yourself, did this really hit the level that it needs to hit to have an executive session? All right, so let's talk about anything on meetings. I'm going to move on now to public records and documents. Anything on meetings that didn't get answered? Sure. Frank.
Clarification, when you have an executive session, then the only subject to be talked about is that which rises to the level of requiring or allowing an executive session.
Mm-hmm.
You can't talk about any other subjects.
That's right. So the question is, if you meet the criteria for one of the exceptions that would allow for an executive session, the only thing you can talk about in the executive session is that material that satisfies the exception, right? And the answer is yes, that's right. You can't get into an executive session for a legal reason and then talk about things that aren't within that exception. Those things have to happen in public. And I should have mentioned that in an executive session, no decisions can be made. You can discuss things, but there's no votes taken. You have to come back into the public session and then take a motion to take an action. So the public is always able to see an action that is taken by the public body. Don't have to, in the case of an executive session, they don't get to see the consensus building that happened in the executive session room, but the vote and the decision always happens in public. All right, public records.
Excuse me, Glenn,
Yes, ma'am.
did you mention anything that the executive session has to be listed on the agenda?
I did not. So Ann asked if did we mention about the executive sessions having to be listed on the agenda. This has always been an interesting one to me because the statute actually says that you can call an executive session during the meeting if something comes up that would allow for it. So if we're in a meeting and again, say it's the planning commission, they're considering a subdivision application and they're about to approve it with a certain condition that there has to be a buffer or something like that. And the applicant gets up and says, my attorney's sitting right here. You can't impose that buffer requirement on me. It's not a legal requirement, and we'll see you in court if you do. At that point, it's actually allowable for the public body to look over to me or whoever's sitting with the public body at that time and say, I think we need some legal advice at this point. And you can then go move into an executive session and get legal advice. But generally, if you know there's going to be an executive session, same rule applies. 7 days in advance, you have to notice it as an executive session, and you have to put on the agenda which of the exceptions apply. You don't have to say much about it. You can say the litigation exception subject to 29 Del Code, whatever it is. You don't have to say litigation for the purposes of discussing the lawsuit against whomever. You don't have to go that far because even allowing your opponent to know that you're meeting an executive session to talk about them as a matter of strategy might signal something to them that you don't want to signal. Question?
You got into attorney-client privilege. Obviously, that exists when there isn't a threat of litigation. How do you preserve the privilege, which is not preserved if it's done publicly?
Right. So the question is, how do you preserve the attorney-client privilege if the lawyer is giving advice publicly?
Yeah, and let's say it's not litigation threatened, but the commission wants to ask for legal advice. That doesn't seem to be in the exception, but if you don't go to executive session,
So that
you've already blown the privilege.
That's right. So the question again is, and it doesn't even have to be litigation related. It can just be on some subject matter where the public body would like to have advice of counsel. Isn't the attorney-client privilege broken if the attorney gives advice in the open session? Generally, what I will do is if that question comes up in a public meeting and it's truly a question that of legal advice, and I think it's something that we need to maintain as confidential, I typically will respond that I prefer not to give that advice in the public session, and I'll either do it through a confidential memorandum to the body, so it would come after the fact, or I'll ask them, I'm trying to think of any other way that we've done it in the past, but typically, no, that's the way I've tried to preserve it, is through a confidential memorandum, and I won't give the advice during the open session. And sometimes that'll mean that the public body then doesn't feel comfortable finishing that discussion or that topic until they get the legal advice. So, but it's a real valid concern that I always have is, am I breaking the privilege here, and am I doing something that is going to be actually detrimental to the client? Public records. So here's what they're, and I read some of the stuff. I know it's boring and dry, but I just need to make the point how broad it is, what a public record is under the Freedom of Information Act. It's information of any kind, owned, made, used, retained, received, produced, composed, drafted, or otherwise compiled or collected by any public body, relating in any way to public business or in any way of public interest or in any way related to public purposes, regardless of the physical form or characteristic by which such information is stored, recorded, or reproduced. So again, very, very broad. If you've got documents related to what you're doing on your committee, you should presume that those documents can be obtained through anybody who wants them in the public. And we'll explain how we get those. So the narrow exemptions regarding what is a public record are very narrow and are generally narrowly construed. So assume everything that is written will end up on the front page of the newspaper or on a troublesome website, because it's just all obtainable. I mean, the phone call, so if you're thinking about writing something down and you have that side of you that says, I really wouldn't want people to see this, think about making a phone call to the person you're intending that information to get to rather than writing it down, because now that you're on a committee or a board, all of those documents are obtainable by the public, even your emails. So if it's an email between two committee members and you think that it's a private discussion, if you're talking about public business, it's not a private discussion and it can be obtained.
Excuse me, Glenn?
Sure.
What do you do in a situation where a meeting is currently taking place and you've got the public texting or emailing the entity that's presenting the meeting?
So technically, those texts are subject to the Freedom of Information Act. They become public documents. And I can't remember a time recently where we've had to get text messages, but I've been involved with instances where text messages of an individual member of a committee, their text messages have been requested through a FOIA request, and we've had to turn over the text messages. So it's text messages, it's even voicemails. I mean, all my voicemails now come to my inbox and they're recordings, and those documents are subject to FOIA. So, I mean, it's really, really broad.
And does that mean that we have an obligation to preserve personal emails that involve committee business of some consensus, an email or a personal
So
email account?
the question is whether you have an obligation as a committee member to preserve emails or voicemails that come to you that are related to public business. This is it's a tough one to answer. We have a document preservation policy in the city. And do you remember if it drills down to individual committee members what their obligation is on emails? And my recollection is, so the way this works is we had to go to the Delaware Archives. The Delaware Archives sets out what types of retention policies different types of organizations around the state should have. And I always felt it wasn't clear enough on committees within a municipality. So I guess the way I would answer it is that there's nothing out there that I'm aware of that forcefully says you're required to retain all those things. So I think if you, in the due course, delete emails, every couple of weeks or whatever, I don't think we're going to get in trouble if that's what you do, because I know of no permanent retention policy. Anything that comes to you, by way of the city's server, so if Ann sends it to you, there's a copy of that on our city server, and that does get retained for some period of time. Right.
I'm curious about how text messages, which seem to be outside of the city servers and everything, and there's a lot of question in the national news about that. How does that work? I mean, how are you dealing with that?
So the question is, what about text messages and those sorts of records that seem to be outside of the city's server? How do we actually deal with those? And that's interesting as well, because there used to be a line of AG opinions that said, if the document is not in the custody and control of the municipality, it's not a public record for purposes of FOIA. All of those cases have been changed now to basically say it doesn't matter if it's a committee member and it's their emails, even on their private computer or on their private phone, if it's related to public business, they are public documents and that need to be turned over. So typically what will happen is we'll get a request, the city will get a request for all the emails relating to a certain application that the Planning Commission received or prepared over the past 2 weeks. So we'll go to the Planning Commission and we'll say, well, first we'll go to our IT person and we'll say, Max, we need to run through the city server these search terms to find all the things that relate to this matter in the last 2 weeks. So we'll do that internally. But then Ann will also send out an email to all the members of the Planning Commission and say, we received this FOIA request. I need you to search your personal computers, phones, whatever it is, for any documents you have that are related to this application over the past 2 weeks. Please bring them into City Hall. And there's a good faith expectation that every committee member is going to do that. We've had instances where committee members have said, you know, all of my emails are so scattered and intermingled, I don't know how to find all that stuff. And Max is able to, if you bring your personal computer in, some people wouldn't feel comfortable doing that, but if you bring your personal computer in, our IT is able to locate all those documents and take them off your computer. So it's not fun. It's one of the things that you deal with as a member of city government, is that your documents are subject to the public asking for them. So again, if it's something that you wouldn't feel comfortable or would be embarrassed by, just don't write it down, don't record it, don't just avoid it as best you can.
One thing that you had brought up in the past, Glenn, was if you're sitting as a member of, say, the Planning Commission or Board of Adjustment, it may be a good idea for you to have a second email just dedicated to that.
Yeah, a lot of people
So
will
we
do that.
wouldn't
They'll
have
set
to
up,
search all the private ones.
right, set up a separate email, you know, Glenn Planning Commission member at gmail.com, and have all your stuff related to city go there, and then it's easier to search that and, you know, find it.
I still question text messages, which seem to be, you know, they're not on servers.
Yeah, they're more difficult to get. There are a couple apps that will allow you to get your text messages, send them to an email address where they can be printed out. That's the way I've. Or just forward and share it. But yeah, the AG's office has said text messages, all of that are subject to it. I can't remember the last time we actually had a run of text messages that we had to get. It's been a while. It's been a while. Yeah. So every municipality has to have a FOIA coordinator. You're looking at her. Ours is Ann Womack. So she has special obligations responding to FOIA requests. So if a FOIA request comes in, we have 15 days to respond to it. There are some allowances within the statute that provide us additional time, but generally she's managing all the FOIA requests that come in. She's managing agendas, making sure that they are published 7 days in advance. Pretty much anything that is FOIA runs through Ann. And you keep a log of the FOIA requests that come in, so you know what documents or records are going out. Yeah. 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 So Ann's plate is full with this stuff. I mean, imagine if you were a much smaller jurisdiction, you know, a very small town with 150 people, and I mean, all these things still apply. And, you know, so it's very difficult for some of these towns to comply with FOIA in a meaningful way, just because it's really not easy. All right, let's talk a little bit ethics, unless anybody wants to talk anything else, Freedom of Information Act. Anybody need a break, or should we keep going? Okay, ethics. So as I said earlier, there is a state code of conduct, and we are all subject to it by virtue of being part of this city government. Statement of policy is, in our democratic form of government, the conduct of officers and employees of the state must hold the respect and confidence of the people. They must therefore avoid conduct which is in violation of their public trust or which creates a justifiable impression among the public that such trust is being violated. So that's kind of the general statement of policy. Standards of conduct. Conflicts of interest are the first one you think about. No state employee, state officer, or honorary state official, which even though most of us wouldn't say we're a state employee, a state officer, or an honorary state official, we are state officers by virtue of being a political subdivision of the state. So you all are actually state officers. No state employee, state officer, or honorary state official may participate on behalf of the state in the review or disposition of any matter pending before the state in which the state employee, state officer, or honorary state official has a personal or private interest. So if your body, this is 101 stuff too. I mean, I always look at this stuff as back in the Boy Scouts, don't lie, cheat, or steal, or tolerate those who do. It's kind of boiled down that way, but here we call it a conflict of interest, which means that if you're participating on a public body, and that public body is deciding a matter that's going to benefit you personally in a way that others aren't benefited, then you have a conflict of interest and you shouldn't vote on that matter. So if I'm a restaurateur and I own 4 restaurants in town, I happen to be on the city commission and we're making a decision that would greatly benefit restaurants or be greatly to their detriment, as a restaurateur, I should not participate in that decision-making, of course. A personal private interest in a matter is an interest which tends to impair a person's independence of judgment in the performance of the person's duties with respect to that matter. So that's the restaurateur example. They've got a personal or private interest. Standards of conduct. So here's drilling down a little bit more. A person has an interest which tends to impair their independence of judgment when any action or inaction with respect to the matter would result in a financial benefit or detriment to accrue to the person or a close relative to a greater extent than such benefit or detriment would accrue to others who are members of the same class or group of persons. So this one gets a little bit, you split hairs a little bit here. I mean, this one really talks about financial gain. Are you going to benefit financially to a greater extent than others in the same class? And that's the language that gets a little bit technical to me, because in my restaurateur example, if the legislation that's being considered is no more beneficial to me as a restaurateur than any other restaurateur, then technically I can participate. I don't have a conflict of interest. But say, for example, that the legislation that's being considered is legislation that would allow a bar area to expand by twice. And I happen to have a large restaurant and I have space that I could expand my bar area by twice. But there are a lot of other restaurants that could never take advantage of this legislation because they don't have the gross floor area to double their bar size. Well, in that instance, it's going to benefit me more than other members of the class. So that one I definitely have a conflict of interest and have to step away. But technically, if all the members of the class, all restaurateurs, are benefited or not benefited in the same way, it's not technically a conflict of interest. I still, in those instances, would be very cautious about participating, even if it's not a technical conflict of interest. Sometimes the perception of a conflict, and we'll get into that when a perception of a conflict matters. But boiled down technically, that would not be a conflict of interest unless it was benefiting you in a way more or less than the same class. Next, the person or a close relative has a financial interest in a private enterprise, which enterprise or interest would be affected by any action or inaction on a matter to a lesser or greater extent than like enterprises or other interests in the same enterprise. So this is sort of the same thing, only deals with companies rather than straight monetary gain. So if for example, your brother has a telecommunications business and city council is considering whether to allow them to have a franchise within the city or not, allowing them is going to allow your brother to, your brother's company to benefit, and that's a conflict of interest for you.
Glenn,
Sure.
What do you consider to be close relatives?
close relatives, I'm sorry, the question was, what do we consider to be close relatives? I think the statute actually provides what a close relative is, it gives a definition, but my recollection is that it's immediate family. It doesn't extend to son-in-laws and those sorts of things. Each state employee, state officer, and honorary state official shall endeavor to pursue a course of conduct which will not raise suspicion among the public that such state employee, state officer, or honorary state official is engaging in acts which are in violation of the public trust and which will not reflect unfavorably upon the state and its government. So that's what I said earlier. Don't lie, cheat, or steal, or tolerate others that do. No state employee, state officer, or honorary state official shall have any interest in any private enterprise, nor shall such state employee, state officer, or honorary state official incur any obligation of any nature which is in substantial conflict with the proper performance of such duties in the public interest. So this one's basically talking about you as members of a public body owe that public body sort of a fiduciary duty. So you can't be involved in outside activities that may in some way cause you to neglect or breach your fiduciary duties to the public body. This comes up sometimes in the case of you might serve on a private board outside of the city. So you're serving on a board over here, and you're also a member of the public body. And the board comes in, or the board that you serve on over here comes before this body that you serve on within the city and is asking the body within the city for money. Well, you've got a fiduciary duty kind of to this body over here as a board member. You also got a fiduciary duty to this body over here as a member of the public body, and those can be in conflict because it's difficult to meet your obligations to both bodies. So in that instance, I would step away. So if you're on a private board, that board is coming before the public body you're on to ask for something, you should step away because that technically is a conflict of interest.
Question about that, to what level do you step away? Is it enough to recuse on voting on something, or does it mean that you shouldn't even discuss your position with the other members of the public?
So the question is, what does it mean to step away? So if you have an instance where you have a conflict of interest, such as the one we just talked about, can you participate in the discussion and then not vote on the matter? And the answer is you cannot participate in the discussion. As soon as you have a conflict of interest, you should recuse and not participate in the decision making. We'll talk about this later, but the reason for that is the idea is you're not supposed to be able to unduly influence the body, so you should recuse it right at the outset. I've even heard people, they want to give an explanation for why they're recusing. I typically say don't even give a reason, because usually when they give the reason, they say, I don't think this legislation is very good, and here's why, blah, 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 but because I'm on this, I'm going to recuse. Well, you've already influenced the group, right? And so and I'll just say that now because it's a slide later, but there's also a theory that you should step out of the room when you recuse and not even stay in the room. I've been in meetings where the person would stay at the dais, I recuse, but I'm going to just sit here, and somebody will say something, and they'll go, they'll make that kind of a reaction. And, so you're still influencing the public body. And even if you're in the room, some people might chill the conversation. Members might not be willing to say certain things about the discussion topic if you're in the room because they know you feel differently. So really, when you've recused, the best option is to leave the room and not participate at all. Yes.
Does anybody covered under this code, do they have to file financial disclosure agreements? I work for the federal government, we always have to do that, so I'm just wondering.
Yep. So the question is, if you're covered under the state code of conduct, you have to file financial disclosures. Everybody in this room does not have to, and I don't think anybody in city government has to, as I think through it. Lobbyists in the state are covered by this code, and they do have to file financial disclosures. And I'm not sure going up the chain whether other state officials have to, but within the city of Rehoboth Beach, none of the financial disclosure stuff applies. Where was I here? Yep. So we're still talking about code of conduct, any of the following, impairment of independence of judgment in the exercise of official. So these are still what constitutes let's see, so this is, at the end, it says, no state employee, state officer, honorary state official shall accept other employment, any compensation, gift, payment of expense, or any other thing of monetary value under circumstances in which such acceptance may result in any of the following. So if you take something that somebody's offering you, does it result in an impairment of independence of judgment in the exercise of official duties? So we're talking about that restaurant example again, right? There's legislation coming before the public body that would benefit restaurants. Well, interestingly enough, the Friday before the Tuesday meeting, every member of council gets a free invitation to this restaurant for a free meal and da-da-da, so because they want to, so that the restaurant wants to be very cozy with the members of council. Does that influence their judgment that, 3 days earlier, they were provided a nice warm meal by, whomever? So that's an instance. An undertaking to give preferential treatment to any person. So again, if somebody does something nice to you, gives you a big whopping Christmas gift because they know that January 6th, you're going to be voting on something that, is beneficial to them, and you give them preferential treatment. The making of a governmental decision outside official channels. So that is, there are ways in which decisions are made within the city, whether they be at the administrative level or at the council level. But this probably goes more toward somebody like the city manager, who normally would consult with a committee or a group of individuals within City Hall. Has something happened that would cause that person to make a governmental decision outside of those official channels? That impaired your judgment. Any adverse effect on the confidence of the public in the integrity of the government of the state. So this is just that perception. If it's something that will cause others to say, something's fishy there, that's activity we just don't want to be caught up in. Other prohibitions are acquiring a financial interest in any private enterprise which such official has reason to believe may be directly involved in decisions to be made by such official in an official capacity on behalf of the city. So if you get inside information that the city's considering an ordinance that's going to be very beneficial to a cable television provider within the city, and then you go out and buy a bunch of stock in that because you know that we're going to do something that's going to increase the value of their stock. Using public office to secure unwarranted privileges, private advancement, or gain. By virtue of being on a public body, you may not believe this, but people are going to see you now as having some moniker of power within the city, and you may be, offered opportunities that, you may be offered privileges or private advancement or gain based upon somebody's knowledge that you have some authority within the city. Disclosing confidential information gained by reason of one's public position or using such information for personal benefit. So that's sort of the insider trading one I was just talking about. Or it could be in an executive session, something's discussed. And let's talk about litigation. So again, litigation, you can go into an executive session, say that we're in litigation, and it just so happens that one member of the public body that's in the executive session happens to be very friendly with the lawyer that's representing the other side. And this person who's in the executive session learns our strategy and decides to go tell the lawyer on the other side what the strategy is. That's this one, disclosing confidential information gained by reason of one's public position. Using the granting of sexual favors, we'll skip that one. All right. Beyond the code of conduct. Okay, so this gets into, we talked about like sort of the clear conflicts of interest. This is stuff that you won't find in the actual state code of conduct, but there's still another layer of ethics that we should all be aware of. So while the state code of conduct provides some guidance for financial so-called actual conflicts, there's a large body of case law regarding constitutional-based conflicts of interest. Even though a particular set of facts and circumstances may not suggest an actual conflict, the same facts and circumstances may nevertheless prohibit the affected individual's participation as a perceived conflict. So there are instances where if whatever activity you're taking is perceived by the public to be a conflict of interest, but maybe it's not an actual conflict of interest that we've just talked about, there are some instances where you still have to step away if the public perceives it as a conflict, and we'll talk about what those are. So the analysis, and this is sort of the technical stuff, is whether you're acting in a legislative capacity or a quasi-judicial capacity. A legislative capacity is basically when you're making laws that are generally applicable to the public at large. So when the city commission is up here and they're deciding whether to change the speed limit on Rehoboth Avenue, that's a legislative action. So that's one way that they can be operating. A quasi-judicial action is more like if you're acting like a judge. So the planning commission is deciding the person's rights with regard to their private property. That's more quasi-judicial. Or the Board of Adjustment is making a determination about whether to grant a variance to an individual or not. That's more quasi-judicial. Or there's a grievance hearing and the city commissioners are making a decision on a disciplinary matter. That's quasi-judicial. So if you're sitting in a legislative capacity where you're just making decisions that are generally applicable and laws that are generally applicable to the public at large, that's a legislative capacity, and the standard is relatively low, and courts will typically be reluctant to interfere with decisions based upon conflict of interest grounds, absent evidence of actual conflict. So, for example, if somebody gets elected to the city commission, or you get appointed to the tree committee, and part of the platform that you ran on was you were going to increase tree canopy by 10%. And you get up and you're lobbying hard for changing tree canopy because all your friends want you to change tree canopy. That's simply a legislative act. And courts aren't going to say they have a conflict of interest because their friends want them to change the tree canopy. That's completely fine. People get elected and people get appointed because of the platforms they run on and the comments they make during the platforms where people get to know them. That's fine. But when you're sitting in a quasi-judicial capacity, adjudicatory, the due process standards regarding impartiality are significantly higher, and consideration of perceived conflicts becomes critically important. So in that instance, I mean, in quasi-judicial capacity, think of it as basically sitting as a judge. You're deciding a person's rights, and there should not even be the perception of a conflict of interest. So the individual who's appearing before the public body in that instance, you may be able to completely adjudicate the matter with impartiality, without any preconceived notions or any biases. But if the person who's before you thinks or perceives that you are biased or have preconceived it, then in that instance, you need to step away. Now, it has to be a reasonable perception. It can't be somebody who just thinks everybody's out to get them or whatever. But if for example, the person who's coming before you, I'm trying to think of a decent example here.
A neighbor is coming before the body you're sitting on.
So neighbors coming before the body, right? So if a neighbor's coming before the body that you're sitting on, and members of the public could say, well, clearly that person on the committee is going to be favorable to that applicant because there's neighbors. They're not going to do anything on that committee that's going to get them sideways as neighbors. So that's a perceived conflict of interest, even if the member of the public body can be completely impartial.
I'm going to push back on that.
Okay.
BOA requires 3 affirmative votes.
Right.
So simply because somebody's a neighbor, if you recuse yourself because you say somebody may feel you are not impartial, you've now made it there are only 4 people sitting. It's not like a court where you can get another judge. So I'm going to push back a little bit.
So the question here is what a,
I don't think that it's simply, because somebody thinks I might be affected by it, because given the way we set up the BOA, recusal effectively is a no vote, because you need 3 out of the 5 people in order for something to be granted.
right, so we're discussing the Board of Adjustment and the fact that you need 3 affirmative votes to get a positive decision on the Board of Adjustment. So if it's simply a neighbor appearing before the board, if the member of the Board of Adjustment is required to recuse in that instance, is that really the way it operates, or is there some other way by which this should be approached? And I guess how I would answer that is, I generally counsel people that when you're appointed to a body or elected, you should want to vote. You shouldn't be looking for reasons to recuse. So in this instance where we're talking about a perceived conflict of interest, I think the way I would advise a Board of Adjustment member is, as to a neighbor, unless and until somebody raises a concern about a perceived conflict of interest, I would generally say you can participate. But if somebody is in the public and raises that as a question, I'm sitting here as a member of the public, I'm a reasonable person, I know they're friendly, they barbecue together, like I feel uncomfortable with this member participating. In that instance, I probably would say it's a perceived conflict of interest and it's reasonable, and I'd probably ask the board member to step away. Question?
Do we, I mean, is there another way to look at this, that you get out in front of that and say, I am a neighbor of Joe Schmo. However, I feel I can be impartial in this matter. So you raise the question up front and indicate that you're willing to be impartial, or is that waving a red flag in front of a bull? You're saying, I think, you wait until someone says, oh, you're Joe Schmo's neighbor. And I'm saying, is what I said another way to look at it? Or what's your reaction, please?
So the question is, if can you get in front of it, and rather than waiting to see if there's somebody that perceives a conflict of interest, whether you can acknowledge the relationship up front and indicate that you feel you can participate impartially, and then ask if anybody has a problem going forward. I kind of like that approach only because I've seen examples of it. Our state is small, so in the judicial system, we'll have judges that sometimes we will appear before them, and a judge will say, I used to practice with this attorney on this side. I was with their firm before I came on the bench. I can be impartial here, but I want you all to know that I do have a relationship with this individual. Are you all okay with me, serving as the adjudicator on this matter? So there are examples, real life examples of it where it occurs in the state judicial system. So I don't mind that approach, I guess, and maybe it's a better approach than sort of waiting to see if there's a perceived conflict of interest.
That follows what you said earlier, is one of the reasons we're appointed to these commissions is to vote.
Right.
And to be as impartial, listen to what's said and vote. So every time you recuse yourself, as Bill said, you're putting different pressure on the remaining people on your commission.
Yeah.
And that to my mind, that allows you to still vote by putting out front what your issue might be. Plus, in terms of the neighbor idea, neighbor is such a subjective comment.
Right.
Some people consider themselves neighbors if they're next door. Others are 6 houses apart or in the same 4 blocks.
Right.
And
That's
so
all.
that's a little bit nebulous, perhaps. But
That's all true, and it becomes really nuanced, some of this, and that's why it's good to have these discussions, because there's never the exact same example twice. And ethics is difficult, and that's why generally I say, if you have the butterflies in your stomach and aren't sure, that's when if your board or committee is represented by another attorney, you should have a conversation with that attorney. If you're represented by the city solicitor, you should have a conversation with me, and we talk these things through, and because it becomes very, very nuanced. There's some that are clear instances of conflict, and you know it when you see it and you step away. There's a lot more though that are, you kind of feel there might be something there, and a lot of times we'll talk it through, and there won't be a conflict that requires a person to step away, and other times we'll make the decision that it does make sense to recuse.
The only example that was given, though, if somebody just was against whatever was going on, they could just raise the conflict of interest question and kind of influence, they're having an influence on the vote that's really beyond the question before the board.
Right.
That seems.
Right, so the question is, what if the person who's in the audience just simply raises the idea of a perception of a conflict of interest, and aren't they then unduly influencing the outcome because a member is then required to recuse because of a perceived conflict of interest? Yeah, these are all difficult things that I don't have great answers for all of them. I mean, that would be another one where an instance where you'd say, okay, is it reasonable for this person to be saying that they have a perceived conflict of interest? What's their basis for that perception? But the ethics stuff it's not easy. But I'm glad you're asking all these questions, because it means you're thinking about it, and you will be while you're participating on your boards and committees. Question?
It just seemed to me that, like when I was on the Board of Adjustment, I know everybody in town.
Right.
They're all my neighbors. So
Yeah.
that bar is really a big gray area.
Yeah, that's exactly right. So. Right, so the comment is that, if you're an individual who's lucky enough to have lots of friends around town, you kind of know everybody, then anything could be a perceived conflict of interest, and where do you draw the line? And I agree 100% with that, and that's why I say they're all nuanced, and every instance is a little bit different than the one before it, and you just have to really think about what level of relationship do you have with this person, and is it reasonable for people to perceive a conflict of interest? And if it is, in those instances, perhaps step away. But if it's just some, I mean, that's Delaware. I mean, you know, everybody knows everybody, especially when you're living in a community that's 1 mile square. So, yeah.
Actually, you know, if you go back to the statute, but it says, you know, are you affected differently than other people in the class? And on zoning matters, we're all affected by it. That's, as you say, we live in a mile square community. And
Right.
as you're living next door, or one of the people who's applying is somebody who you know, I personally don't think that that should be grounds for recusal, particularly when we set the BOA up. And I think to think about it, am I going to be affected different than other people in town? Because that's what the example you gave on the restaurants. And I think we think of it that way, then it really does come down to, you know, is the fact that I'm really right next door really going to be different for me than everybody else who's going to be going by this place where they want an arbor or something else?
Right, so the question is, shouldn't we think about this in terms of whether you're affected different than other people in the class? Because we were talking about that earlier in the terms of conflict of interest. And I think the answer is yes to some extent, but I don't want you to leave thinking that the types of conflict of interest we're talking about now is the standard type of conflict of interest we talked about a little bit earlier. This is the stuff that, you know, it's beyond the legislative stuff. Now you're in the quasi-judicial capacity where it's really a heightened level of scrutiny. So if you go to the courts you're sitting legislatively here, you're sitting quasi-judicial here, the legislative cases, those are almost never winnable. If somebody's challenging the legislator in the decision that they made or participating in something, if it was a legislative action, rarely is the member of the public body found to have been wrong in participating. In the quasi-judicial stuff, especially the judges in this state, they're very quick to sort of say there's a higher standard here because you're acting like a judge, and you have to avoid even the perception of a conflict of interest. So I think a little bit, I agree, but I do think that you just if you're sitting in that type of a role, just always remember the standard's higher. You've got to think about perceptions of a conflict of interest, not just actual conflicts of interest. Question.
One other point, I go back to something you said a little earlier that Fred Townsend has shared with us also, is that when you are, when you think you might have an issue, the best thing, since we know the applicants in advance, we have that information from Ann's fantastic job of
Right.
keeping us informed. I don't know how you do it, Anna. Anyway, we have this information. Then the best thing to do is talk to the attorney who's representing the board in advance and say, here's my situation with this applicant or this representative of that applicant, and what do you think? That seems to be, that was, I think, what you suggested earlier, is possible to talk to our own representatives.
Right.
And say, is this recusable, or is this something, how should we handle it? The upfront thing, the wait and just be surprised, or how do we?
Right. So the comment is that we're lucky enough to typically get the information on certain applications well in advance, and doesn't it make the most sense that if you think that there might be an issue, that you should talk with your legal representative about whether there's a conflict that rises to the level that requires recusal, and that's I couldn't agree more. Now, of course, you know, we should use our legal resources within the city, you know, somewhat sparingly, because it costs money every time I get called or Fred gets called or whomever. But if there's a real concern about it, then the mayor has always been good about that. He doesn't want members participating if they have a conflict that would require them to recuse. So if you feel as though that's a discussion you would like to have, he's always been supportive, and so has the past city managers. So that's quasi-judicial and legislative. Here's a case, Ashirno versus Folsom. Said a public officer acting in a quasi-judicial capacity is disqualified to sit in a proceeding in which there is a controverted issue as to which he has publicly expressed a preconceived view, bias, or prejudice. Such officer must disqualify himself if he has prejudiced the case or has given a reasonable appearance of having prejudiced it. It is fundamental that a quasi-judicial tribunal, like a court, must not only be fair, it must appear to be fair. So that kind of sums up what we've been talking about. This says the same thing through another court. Here's maybe a quote that'll help on this issue. A perceived conflict of interest is separate and distinct from an off-cited participation as a member of the public. Restated, even if an individual is permitted to participate in a particular process as a member of the public, he or she can still be disqualified from future processes due to a perceived conflict of interest. And the way that works is, here, this slide actually explains it. Delaware law does not prohibit officials from participating in processes simply because the individual is a city official where there is no actual or perceived conflict of interest. But here's an example. For example, there's no per se rule prohibiting a city commissioner from participating in a hearing before the Rehoboth Beach Planning Commission as a member of the public. So say if there's an application before the Planning Commission and a member of the city commissioners appears before the Planning Commission and says, I like this application and here's the reason why. It's going to provide exactly the type of housing that we need in this area. I think the housing is the right size and scale. You know, I like the builder's a good builder, and participates there. And say the Planning Commission approves that application, then somebody appeals the Planning Commission's decision to approve it. The body that hears that appeal is the city commissioners. So now that application is coming before the city commissioners. That city commissioner that participated at the Planning Commission and said, I'm here as a member of the public, I love this, now has to recuse because they've prejudged the application and there's some preconceived notions. And this is the recusal slide that we talked about earlier. Should I stay or should I go? And we said earlier that the best practice is to leave the room, and there's no explanation necessary. That is all I have. I appreciate you guys all coming because I know it takes a while to get through this stuff. It can be very, very dry. But any questions before we wrap up? And anything I missed that you wish I had included?
Another avenue for, if you're concerned about conflict of interest, would be the PIC Commission, Public Integrity Commission.
Right. So there's a Public Integrity Commission that deals with the ethics issues. So again, I said you were subject to the state code of conduct. If somebody believes that you have violated the state code of conduct, they can file a petition with the Public Integrity Commission. The Public Integrity Commission then will review the instance and make a determination as to whether there was a ethics violation or not. But one option you have as a member of a public body is the Public Integrity Commission will issue advisory opinions. So if something is coming before you and you've spoken with me or you've spoken with whatever other legal representative represents your body and you're still not sure about whether you should participate or not, you can write to the Public Integrity Commission and say, here's my scenario. Am I able to participate in this or should I recuse? And they will give an advisory opinion. And the nice thing about an advisory opinion is that once you have that opinion, if you participate and somebody claims you shouldn't have, the Public Integrity Commission will never come back and say, yeah, that was a violation because you've got their, and that stuff's all confidential. So you can keep their advisory opinion confidential to you until somebody challenges you when you're participating and they say, you shouldn't be participating because I know you've got a conflict of interest. You can whip out that opinion and say, I've already talked to the Ethics Commission at the state level and they said I'm fine to go ahead. So that is an option for you if the resources within the city haven't given you the level of comfort that you're looking for. One more.
Yeah, I have a question. I'm not trying to, catch you here, but in one sense, you said that if, in the last example you gave of a commissioner going before, say, the Planning Commission, and expressing a position on a particular subject, and then not having to recuse when they come back. But on the other hand, you said that in a legislative as opposed to a quasi-judicial, that the bar is much lower and that almost nobody ever gets called on that. So where is the line?
So I'm glad you're drawing that distinction. So the question was that I just gave an example that a member of the city commission appearing before the Planning Commission could not then participate on an appeal that comes before the city commissioners. And how is that different based upon being in a quasi-judicial capacity versus a legislative capacity? So for example, if the Board of Commissioners referred to the Planning Commission a zoning, a general zoning law that they're considering that would be generally applicable to the city as a whole. And they said to the planning commission, we'd like you to give us a recommendation. And a member of the planning commission, because that's a legislative action, there's going to be a change to the zoning laws that general applicability. And a member of the city commissioners went before the planning commission and said, I think it's a good idea. In fact, I'm the one who brought it up at the city commissioners level, and here's why I like it, and I'd like you to consider this. And then the planning commission makes a recommendation back to the city commissioners. Can that city commissioner then participate at this level? And my answer would be yes, because that's purely legislative. You're allowed to, take positions and lobby for things when it's legislative. So I think in that instance, the city commissioner would be allowed to participate. Yeah. But again, it gets nuanced and technical, so you should ask questions. It's not quasi-judicial, right? Purely legislative. And if I'm doing my job and the others are doing their jobs, I mean, when we spot one of these issues, we'll typically raise it with you. It won't be in an open session. I mean, I will send you a memo or I'll call you individually and say, hey, this is a thing that we should talk about and figure out whether you should participate or not. So there's hopefully we're a little bit of a backstop looking out for those instances too. So, anything else? Thank you everybody for attending. We're done.